You know those chaotic Zoom meetings, right? Where everything just goes wrong, someone's on mute, someone else can't find the chat. Well, what if that confusion didn't just end in an awkward silence, but in a full-blown lawsuit? Okay, let's dive into a really fascinating case that started in a virtual homeowners association meeting and ended up in front of an administrative law judge. I mean, it's such a modern-day problem, isn't it? And that's exactly what we're going to dig into here. We're going to break down the official court documents to see how that quick shift to online life can spark a very, very real legal battle. And we're not talking about a simple little disagreement here, no. The official hearing notice lays out the core legal question. Did the association violate specific state statutes and its own bylaws? These are the rules that govern everything from how meetings are run to how elections are held. The stakes were absolutely real, and the fight was formal. All right, so let's set the scene for this, I guess you could call it a courtroom drama. On one side, we have a homeowner, a guy named Samuel Paparazzo. And on the other, the Coronado Ranch Community Association in Gilbert, Arizona. This is their story. Okay, real quick, let's get the lingo down so we're all on the same page. The petitioner, that's the homeowner, Mr. Paparazzo. He's the one who filed the complaint. The respondent, that's the HOA, the ones who had to answer for it. Got it? Cool. Petitioner versus respondent. Now the context here is everything. I mean, just look at these dates. This is all going down in that absolute whirlwind of March 2020. The HOA plans a totally normal in-person meeting, and then bam, the world flips upside down. A pandemic hits, executive orders are flying, and they have just a matter of days to pivot an entire community meeting to some online platform. You can just feel the chaos, right? And that chaos is the backdrop for literally everything that happens next. So, with that crazy scene set, how did this whole thing actually escalate into a legal fight? Well, the homeowner, our petitioner, didn't just have one problem with the meeting. He came with 4 very specific allegations against his HOA. And here they are, the 4 main pillars of his case. First, he argued that the notice for the new virtual meeting was way too short. Second, and this is the big one, he claimed he was actively blocked, denied his right to speak through the online chat. Third, a procedural issue. He said the president didn't call the meeting to order correctly. And finally, he alleged the board election itself was totally unfair. These are some pretty serious claims. But, there are always 2 sides to a story. So how did the Coronado Ranch Community Association, the respondent, fire back against these 4 allegations? Let's break down their defense, point by point. All right, for that first claim about improper notice, the HOA basically said, look, we did everything we possibly could in a global crisis. And they brought the receipts. A dozen signs posted at community entrances, 3 mass emails to 750 members, and they even put signs at the original physical location on the day of the meeting, just in case somebody showed up there. Pretty thorough, right? Now for that really juicy claim of being blocked from the chat, this is where things get really specific. The HOA's records showed that during that same meeting, 26 other members successfully sent messages. 26. So if the platform was working perfectly for them, what in the world was happening on the petitioner's end? And those last 2 allegations, yeah, they kind of fell apart under scrutiny. The HOA pointed out the president did call the meeting to order before handing over the reins, which is perfectly allowed. As for the unfair election, turns out they didn't even have an election in 2019 because not enough people showed up. So, by necessity, all 5 board seats were up for grabs in 2020. In fact, the court documents show the petitioner himself basically conceded these 2 points during cross-examination. So there you have it. The allegations on one side, the defense on the other, all the evidence is on the table. Now it's all up to the administrative law judge to weigh the facts and make the final binding decision. And to make that decision, the judge uses a legal standard called preponderance of the evidence. It sounds complicated, but it's pretty simple. It's not like a criminal case where you need proof beyond a reasonable doubt. It just means the judge has to be convinced that it's more likely than not that one side's version of the story is true. It's really just a question of probability. Which brings us right back to the central mystery of this whole case. It's the one question the judge really had to answer. If the technology was working just fine for 24 other residents, what went so wrong for our petitioner, Mr. Paparazzo? And here we have it, the judge's conclusion. It wasn't some grand conspiracy. It wasn't a technical glitch on the HOA side. The official ruling, and I'm quoting directly from the decision, states that the problem was, quote, user error. Yep, here's the simple, almost unbelievable explanation for this entire lawsuit. According to the evidence, the homeowner had typed his messages into the chat box, but he never actually sent them. He didn't hit enter or click the send button. He was essentially talking to himself in a draft message. And based on that one finding, all the other dominoes just fell into place. The judge concluded that the notice for the meeting was perfectly fine, especially given the pandemic. And crucially, that the HOA isn't responsible for a member's personal tech skills. The meeting and election were lawful, and therefore the homeowner failed to meet that preponderance of the evidence standard. And with that, the final verdict was delivered. After all the arguments, the evidence, and the testimony, the judge's decision came down clear and simple. Petition denied. The case was over. So, a lawsuit over not pressing a button might seem a little minor, but this case actually has some really important things to say about the world we all live in now. Let's zoom out and look at the key takeaways. First, it shows that courts can be flexible, granting some leeway to organizations that are forced to adapt in a huge crisis. Second, it's a perfect snapshot of the tech learning curve we've all been on. But the most important takeaway here is about personal responsibility. This ruling sets a precedent that basically says, while an organization has to provide a platform that works, users are expected to understand its most basic functions. In the eyes of the law, not knowing how to hit send isn't the platform's fault. And that leaves us with this final, really thought-provoking question. The line is blurring every single day between our physical and our digital lives. So this case forces us to ask, in this new world, where does an organization's duty to help us out end? And where does our own responsibility to just learn begin? It's something we're all going to have to figure out, one virtual meeting at a time.